Welcome to episode 31 of the Supreme Court Opinions Read podcast, where we read Supreme Court opinions so you don't have to. My name's Bailey, and I'll be reading the Supreme Court's opinion in Galette versus New Jersey Transit Corporation. The case was decided March 4th, 2026. And as always, we'll start with the syllabus. In 1979, the New Jersey legislature created the New Jersey Transit Corporation, NJ Transit, as a body corporate and politic with corporate succession and constituted it as an instrumentality of the state exercising public and essential governmental functions but independent of any supervision or control by the New Jersey Department of Transportation. The state gave NJ Transit significant authority, including the power to make bylaws, sue and be sued, make contracts, acquire property, raise funds, own corporate entities, adopt regulations, and exercise eminent domain powers. NJ Transit's organic statute provides that no debt or liability of the corporation shall constitute a debt or liability of the state, and that all expenses shall be payable from funds available to the corporation. NJ Transit is governed by a board of directors. The governor may remove board members and may veto board actions. The legislature may veto some eminent domain actions. NJ Transit is now the third largest provider of bus, rail, and light rail transit, operating within an area that includes New Jersey, New York City, and Philadelphia. In 2017, Jeffrey Colt was struck by an NJ Transit bus in Midtown Manhattan. A year later, Cedric Gillette was injured when an NJ Transit bus crashed into a car in which he was a passenger in Philadelphia. Both sued NJ Transit for negligence in their respective home state courts. NJ Transit moved to dismiss both lawsuits, arguing that it is an arm of New Jersey entitled to sovereign immunity. The New York Court of Appeals held that NJ Transit is not an arm of New Jersey. The Pennsylvania Supreme Court held the opposite, concluding NJ Transit is an arm of New Jersey. This court consolidated the cases and granted certiorari to resolve the conflict. Held, NJ Transit Corporation is not an arm of New Jersey and thus is not entitled to share in New Jersey's interstate sovereign immunity. Part A. Sovereign immunity is personal to the state and extends only to arms of the state itself, not to legally independent entities that the state creates. Whether an entity is an arm of the state is a question of federal law, answered by considering the provisions of state law that define the agency's character. Section 1. The court's early cases focused on whether an entity was a separate legal person from the state, with the corporate form serving as a key marker of separate legal personhood. A corporation was understood as an artificial person that could sue and be sued by its own members and contract with them as with any strangers. In Bank of United States versus Planters Bank of Georgia, the court held that a state-chartered bank was not an arm of Georgia because it was a corporation and judgments would be satisfied by the corporation's property, not the state's. Subsequent cases reaffirmed this holding even when the state exerted significant control over the bank. The court also applied the same reasoning to cities and counties created as municipal corporations. Section 2. Beginning in the mid-20th century, the court began taking a more holistic view of an entity's relationship with the state, but remained focused on whether the state structured the entity to be legally separate, with corporate status remaining central. In Moore v. County of Alameda, the court held that a county was not an arm of the state because it was created as a body corporate and politic with corporate powers, and the county alone would be liable for all judgments against it. In Mount Healthy Board of Education v. Doyle, the court framed the inquiry as asking whether an entity is more like a county or city than like an arm of the state, and concluded a local school board was not an arm of the state. In Lake Country Estates Inc. v. Tahoe Regional Planning Agency and Hess v. Port Authority Trans-Hudson Corporation, the court found that two bi-state entities were not arms of the state where they were created as separate legal entities. Judgments against the entities were not binding on the states, and the entities generated their own revenues and paid their own debts. Part B. The court's precedents have consistently and predominantly examined whether the state structured the entity as a legally separate entity liable for its own judgments. The clearest evidence of legal separateness is when the state created a corporation with traditional corporate powers to sue and be sued, hold property, make contracts, and incur debt. A state might create a corporation precisely because of its independent legal status, allowing the state to distance itself from burdens the corporate entity may incur. When a state makes such a decision, courts should presume the corporation enjoys all the advantages and disadvantages of separate legal status, including that it is no longer part of the state itself. Other aspects of state law may also indicate legal separateness, such as defining the entity as a separate legal entity or excluding it from the definition of state for other purposes. The court's precedents also focus on whether an entity is liable for its own judgments or whether the state is formally liable. One central rationale for sovereign immunity is protecting states' ability to make their own decisions about the allocation of scarce resources. If the state is formally liable for judgments against an entity, that entity is more likely an arm of the state. An entity's practical financial relationship with the state, such as an expectation that the state would cover its judgments if needed, or the state's history of subsidizing the entity, has less relevance. Finally, courts may consider the degree of control the state exerts over the entity, but should do so with caution because ultimate control of every state-created entity resides with the state, even those that are not arms of the state. Gauging actual control can be a perilous and unreliable inquiry. The court has never found a corporation liable for its own judgments to be an arm of the state, even when the state had significant control, including cases where the state was sole shareholder, possessed appointment and removal powers, and managed the entity's affairs. Part C. Even if an entity is not an arm of the state, a particular suit or remedy may require dismissal due to sovereign immunity if the state is nevertheless the real party in interest. Because NJ Transit never argued that New Jersey is the real party in interest in either of these cases, dismissal on this ground is not implicated here. Part D. Applying these principles, NJ Transit is not an arm of New Jersey. To start, New Jersey structured NJ Transit as a legally separate entity. It was created as a body corporate and politic, with corporate succession possessing typical corporate powers such as the power to sue and be sued, enter into contracts, and acquire property. NJ Transit's corporate status serves as strong evidence it is not an arm of the state. Although NJ Transit's organic statute labels it an instrumentality of the state, that term lacks the historical weight of the corporate form and says little about arm of the state status. Other aspects of New Jersey law undercut any inference from the term instrumentality. The New Jersey Tort Claims Act and Contractual Liability Act exclude entities with sue and be sued authority from the definition of state. Second, as NJ Transit concedes, the state is not formally liable for any of NJ Transit's debts or liabilities under New Jersey law. Finally, the control New Jersey exerts over NJ Transit does not change the conclusion. Although the state exerts substantial control, for example, governor's appointment and removal powers, cabinet member chairing the board, gubernatorial veto power, legislative veto over some eminent domain actions, New Jersey law also states NJ Transit shall be independent of any supervision or control by the Transportation Department and requires it to exercise independent judgment. This level of control does not meaningfully affect NJ Transit's status with respect to the arm of the state analysis, given that it is a legally separate corporation responsible for its own judgments. Part E. NJ Transit's and its amici's counterarguments are unavailing. NJ Transit contends corporate status is not dispositive, but NJ Transit is a corporation with all the hallmarks of separate legal personhood, and the court has not previously found a similarly structured corporation to be an arm of the state. NJ Transit's reliance on State Highway Commission of Wyoming versus Utah Construction Co. is misplaced because that case concerned whether the state was the real party in interest in a particular contract dispute, not whether the entity was in the abstract an arm of the state. NJ Transit argues its description as serving public and essential governmental functions and its delegation of substantial public powers demonstrate an intent by New Jersey to create it as an arm of the state. The arm of the state analysis, however, focuses not on whether the entity serves public functions, but on whether the state chose to serve those functions through its own apparatus or through a legally separate entity. Cities and counties serve public functions and exercise police powers but are not arms of the state. Assessing what qualifies as an essential governmental function can also be unsound in principle and unworkable in practice. NJ Transit also contends that the court should consider its practical financial relationship with the state, including the degree of state funding and the likelihood the state would pay its judgments. Neither Lake County nor Hess supports this position. Lake County's discussion of practical consequences relied on real party and interest cases, while its arm of the state analysis discussed only whether the compact expressly provided that obligations would not bind the states. Hess focused on whether the compact or state laws required the states to bear judgments, concentrating on formal liability rather than the entity's practical financial relationship with the state. Hinging arm of the state status to practical realities of state funding also risks arbitrary distinctions and inconsistent treatment, as illustrated by New Jersey's funding of NJ Transit's operating budget oscillating from 15% to 46% over 35 years. Finally, NJ Transit points to cases outside the sovereign immunity context to argue that the court should place more weight on the state's control over and practical financial relationship with the entity. Those cases, however, warned that an entity can count as part of the state for some but not other purposes, and thus have little bearing on the arm of the state analysis. Amici states urge the court to adopt a rule that a state's own characterization of an entity should be dispositive. This position focuses on the label the state places on an entity rather than on whether the state structured the entity as legally separate. It also prioritizes one characterization, instrumentality, over another, body corporate, and there is no good reason to believe the state intended NJ Transit to be part of the state itself by using instrumentality when it simultaneously used body corporate, a term traditionally understood to create a separate legal personality. The state's preferred test does not promote predictability because it still requires courts to decide which state law pronouncement is dispositive. Consistency is promoted by adhering to the long line of cases finding state-created corporations formally liable for their own judgments not to be arms of the states that created them. States maintain the power to structure themselves as they wish and are free to amend their laws if they intend corporate entities to remain part of the state and for the state to assume their liabilities. Justice Sotomayor delivered the opinion for a unanimous court. States are generally entitled to immunity from being sued in another state's courts without their consent. That sovereign immunity is personal to the state and thus extends only to arms of the state itself, not to legally independent entities that the state creates. This pair of cases arises out of two accidents, one in New York City and one in Philadelphia, in which New Jersey Transit buses struck and injured people. Both victims sued New Jersey Transit, a corporation created by the New Jersey legislature, in their respective home courts in New York and Pennsylvania. The highest courts in those states diverged as to whether New Jersey Transit is an arm of New Jersey. The court granted certiorari to resolve whether New Jersey Transit is an arm of New Jersey and thus entitled to the state's sovereign immunity. It is not. Accordingly, the judgment of the New York Court of Appeals is affirmed and the judgment of the Pennsylvania Supreme Court is reversed. Part 1, Section A. Starting in the 1960s and 1970s, New Jerseyans increasingly drove to work. This shift led railroads to curtail commuter rail services connecting the New Jersey suburbs to New York City and caused significant highway congestion. The New Jersey legislature responded by providing heavy subsidies and operational assistance to the major private rail and bus companies that served the region, but service remained severely fragmented. In search of a new solution, the legislature in 1979 created the New Jersey Transit Corporation, NJ Transit. The state structured the entity as a body corporate and politic with corporate succession. The corporation was constituted as an instrumentality of the state exercising public and essential governmental functions. It was allocated within the Department of Transportation, but the corporation was independent of any supervision or control by the department or by any body or officer thereof. The state gave NJ Transit significant authority. For instance, it has the power to make its own bylaws, sue and be sued, enter into contracts, acquire or deal in and with real or personal property, raise funds from fares, gifts, grants, or loans, own and control any corporate entity acquired or formed to carry out its objectives, adopt rules and regulations as necessary, and exercise eminent domain powers. Moreover, NJ Transit's organic statute provides that no debt or liability of the corporation shall be deemed or construed to create or constitute a debt, liability, or a loan or pledge of the credit of the state. It also states that all expenses incurred by the corporation shall be payable from funds available to the corporation, and that no liability or obligation shall be incurred by the corporation beyond the extent to which monies are available. The corporation is governed by a board of directors. The board has 13 members, 11 of whom are voting members. The voting members consist of 3 ex officio members from the governor's cabinet, 6 members appointed with the advice and consent of the Senate, and 2 members appointed on the recommendation of the President of the Senate and Speaker of the General Assembly. The governor may remove any board member, 8 of whom only for cause, and may veto any action the board takes. The legislature may also veto some eminent domain actions. Once created, the board adopted its own bylaws and hired a president and CEO to manage day-to-day operations. It then acquired and consolidated the assets of several major rail and bus services operating in and around New Jersey. In the last several decades, the legislature has appropriated funding for NJ Transit's operational budget each year, covering anywhere from 15 to 46% of that budget. NJ Transit also receives funding from the state and the federal government for its capital projects. Footnote 1. This is just a citation to that effect, so I'm not going to read it out. Carrying on. NJ Transit's revenues have fluctuated over time. In 2024, it generated $832 million in operating revenues. Footnote 2. This is just a citation to that effect, so I'm not going to read it out. Carrying on. Today, NJ Transit is the nation's 3rd largest provider of bus, rail, and light rail transit, operating within a 5,300 square mile area that includes New Jersey, New York City, and Philadelphia. Section B. In 2017, Jeffrey Colt was crossing 40th Street in Midtown Manhattan where an NJ Transit bus struck him and knocked him to the ground. A year later, Cedric Galette was a passenger in a car driving down Market Street in Philadelphia when an NJ Transit bus crashed into the car. Both were seriously injured. Colt and Galette sued NJ Transit for negligence in their respective home state courts, Colt in New York and Galette in Pennsylvania. NJ Transit moved to dismiss both lawsuits, arguing that it is an arm of New Jersey and thus entitled to New Jersey's sovereign immunity. The New York Court of Appeals held that NJ Transit is not an arm of New Jersey. The court first observed that the federal courts of appeals have analyzed whether an entity is an arm of the state using an array of multi-factor and multi-step tests. Footnote 3. This is just a citation to a number of cases to that effect, so I'm not going to read them all out. Carrying on. It then distilled from those cases a 3-factor inquiry. 1. How the state defines the entity and its functions. 2. The state's power to direct the entity's conduct. And 3. The effect on the state of a judgment against the entity. Applying those factors, the court held that NJ Transit is not an arm of New Jersey and that Colt's suit could thus proceed. The Pennsylvania Supreme Court, however, held the opposite, concluding that NJ Transit is an arm of New Jersey. It applied its own 6-factor test, which considers 1. The legal classification and description of the entity within the governmental structure of the state, both statutorily and under its case law. 2. The degree of control the state exercises over the entity, both through the power of appointment and the power to subsequently veto its actions. 3. The power of the entity's board to independently raise revenue on its own. 4. The degree of funding provided by the state to the entity relative to other funding sources. 5. Whether any monetary obligation incurred by the entity is binding upon the state. And 6. Whether the core function of the entity can be categorized as a function which is normally performed by local government or state government. Under that test, the Pennsylvania Supreme Court concluded that NJ Transit is an arm of New Jersey and thus dismissed Galette's suit. This court granted certiorari to resolve the conflict and consolidated the cases. Footnote 4. After this court granted certiorari, NJ Transit filed an application for stay of Colt's pending damages trial in the Supreme Court of the State of New York. This court stayed the trial pending issuance of the mandate in these cases. Carrying on. Part 2. A state's immunity from suit is a fundamental aspect of the sovereignty which the states enjoyed before the ratification of the Constitution and which they retain today. State sovereign immunity bars private parties from suing a non-consenting state in that state's own courts or in the courts of another state. In so doing, it prevents the indignity of subjecting a state to the coercive process of judicial tribunals at the insistence of private parties. It also protects the state from being thrust against its will into the disfavored status of a debtor subject to the power of private citizens to levy on its treasury. Sovereign immunity, however, is personal to the state itself. It does not extend to lesser entities such as municipal corporations or other governmental entities that are not arms of the state. Whether an entity is an arm of the state is a question of federal law that can be answered only after considering the provisions of state law that define the agency's character. Before addressing whether NJ Transit is an arm of New Jersey, the court first sets forth the principles that have guided the arm of the state inquiry in its precedents. Section A, subsection 1. When examining the relationship between the state and an entity it created, this court's early cases focused on whether the entity was a separate legal person from the state. One key marker of separate legal personhood was the corporate form. At common law, a corporation was an artificial person existing in contemplation of law and endowed with certain immunities, privileges, and capacities in its collective manner, which do not belong to the natural persons composing it. As a result of its separate legal personhood, a corporation could sue and be sued by its own members and contract with them in the same manner as with any strangers. This court first applied this idea of corporate personhood to the arm of the state inquiry in Bank of United States versus Planters Bank of Georgia. It held that a state-chartered bank was not an arm of Georgia because it was a corporation and the judgment would be satisfied by the property of the corporation, not by that of the individual corporators. Chief Justice Marshall explained that the state of Georgia, by giving to the bank the capacity to sue and be sued, voluntarily strips itself of its sovereign character so far as respects the transactions of the bank and waives all the privileges of that character. Subsequent cases reaffirmed Planters Bank's holding, relying on the corporate status of other state-chartered banks to deny them sovereign immunity. That was true even when the state exerted significant control over the bank, such as by being its sole shareholder or possessing appointment and removal power over its officers. The court applied the same reasoning to cities and counties that were created as municipal corporations. The court explained that the corporate form of such entities, which included the power to sue and be sued, likewise made them legal persons separate from the sovereign and thus not entitled to share in the state's sovereign immunity. Employing similar logic, the court also held that entities created by the federal government were not its arms when they possessed the separate personhood of a corporation. Subsection 2. Beginning in the mid-20th century, the court began to consider additional features of an entity's relationship with the state in the arm of the state inquiry. Even so, the analysis remained focused on discerning whether the state had structured the entity to be legally separate, and corporate status remained central to that analysis. For example, in Moore v. County of Alameda, the court addressed whether a county was an arm of the state and therefore not a citizen for purposes of diversity jurisdiction. The county at issue argued that its designation by the California Constitution as a legal subdivision of the state enshrined its status as an arm of the state. The court, however, disagreed. It explained that the county was also created as a body corporate and politic, which meant, most notably, that the county was given corporate powers such as the ability to sue and be sued, to deal in property, and to make contracts. Financially, moreover, the county alone would be liable for all judgments against it and could issue bonds without creating an obligation on the part of the state. Finally, the court observed that given the county's corporate status, the California Supreme Court had held that counties could be sued by the state. The court thus concluded that the county was not an arm of the state because the county had a sufficiently independent corporate character. Resting on the firmly established rule that municipal corporations and counties are not arms of the state, the court in Mount Healthy City Board of Education versus Doyle framed the arm of the state inquiry as asking whether an entity is more like a county or city than like an arm of the state. In answering that question for the entity at issue, a local school board, the court examined the characteristics of the board under state law. It observed that the board was created as a political subdivision distinct from the state, that it had powers to issue bonds and levy taxes, and that it received money and guidance from the state. Those characteristics led the court to conclude that the board was more like a county or city and thus not entitled to immunity. The court again asked whether an entity was comparable to a county or municipality, or rather an arm of the state, in Lake Country Estates Inc. versus Tahoe Regional Planning Agency. There, the entity at issue was the Tahoe Regional Planning Agency, a bi-state entity created by California and Nevada alongside the federal government under the Compact Clause. The court explained that the Interstate Compact created the agency as a separate legal entity and a political subdivision, and that judgments against the agency were not binding on either state. The court also observed that most of the agency's governing members were not appointed by the states, that its rulemaking authority was not subject to any state-level veto, that the agency's function, land use regulation, was a traditional local government function, and that California had previously sued it. The agency, the court concluded, was therefore not an arm of either state. Finally, in Hess versus Port Authority Trans-Hudson Corporation, the court again found that a bi-state entity created under the Compact Clause was not an arm of the state. It explained that the authority was described in the compact and state laws as a joint or common agency, a body corporate and politic, and a municipal corporate instrumentality of New York and New Jersey. Financially, the states were not liable for the authority's debts or judgments. The authority was barred from pledging the credit of either state or from borrowing money in any name but its own, and the entity generated its own revenue. The court acknowledged that the states exerted significant control over the authority. They had appointment and removal power over its commissioners, the governors could veto the authority's actions, and the states' legislatures could determine what projects the authority would pursue, but rejected control as a dispositive factor in its overall analysis. In the end, after considering the above facts and underlying purposes of sovereign immunity, the court concluded that the authority's status as a discrete entity that generates its own revenues and pays its own debts ultimately rendered it not an arm of the state. Section B. Although the court's arm of the state cases have accounted for various considerations over time, those precedents have consistently and predominantly examined whether the state structured the entity as a legally separate entity liable for its own judgments. The clearest evidence that a state has created a legally separate entity is that it created a corporation with the traditional corporate powers to sue and be sued, hold property, make contracts, and incur debt. The corporate form is particularly salient because it has long been settled as a matter of American corporate law that separately incorporated organizations are separate legal units with distinct legal rights and obligations. Indeed, separate legal personality has been described as an almost indispensable aspect of the public corporation. In fact, a state might choose to create a corporation rather than an unincorporated government agency precisely because of its independent legal status. This move allows the state to distance the entity from burdens that apply to the state itself, or to distance the state from the burdens that the corporate entity may incur. For instance, states initially created banks as corporations in part because states themselves are not permitted to emit bills of credit under the Constitution. States have also created corporations to circumvent state constitutional debt limitations placed on state agencies. When it comes to facilitating certain projects, such as high-risk long-term capital investments, states may establish corporations in order to shield themselves from the responsibility and, more importantly, the liability that the corporation's projects may incur. When a state makes such a decision, courts should presume that the corporation enjoys all the advantages and disadvantages of separate legal status, including the fact that the corporate entity is no longer part of the state itself. The corporate form, however, is not the only structure that signals the state has created a legally separate entity. Other aspects of state law may indicate legal separateness as well. Most obviously, the entity could be described as a separate legal entity. State law also might define the entity as not part of the state for other purposes. The ultimate question remains whether the state structured the entity as part of itself or as legally independent. The court's precedents also focus on whether the entity is liable for its own judgments or whether the state is formally liable, i.e., whether any judgment against the entity must be satisfied out of the state treasury. One of the central underlying rationales for state sovereign immunity is protecting states' ability to make their own decisions about the allocation of scarce resources. If the state is formally liable for judgments against an entity, that entity is more likely to be an arm of the state because its liabilities necessarily undermine the state's ability to make choices about how to allocate the state fisc. In contrast to formal legal liability, an entity's practical financial relationship with the state, such as its expectation that the state would cover its judgments if needed, has less relevance. Just as a state cannot lose its sovereign immunity by requiring a third party to reimburse it, such as by buying insurance, a state cannot imbue an entity with its immunity simply by agreeing to pick up the tab, such as by choosing to indemnify the entity. Similarly, a state's history of subsidizing an entity carries little weight. State governments routinely fund nonprofits, private corporations, and municipalities, but the receipt of those state funds does not mean that those entities become part of the state itself, even when the funding is a significant amount. Finally, the court's cases also suggest that courts may consider the degree of control the state exerts over the entity, but courts should do so with caution. Control is not especially probative because ultimate control of every state-created entity resides with the state, even those that are not arms of the state. Cities, counties, school boards, and state-created banks have all been recognized as legally separate entities from the states, even though the state may destroy or reshape any of these entities that it created. Further, gauging actual control can be a perilous inquiry and an uncertain and unreliable exercise. That is because the state might exercise control through various formal and informal levers, from appointing and removing officers to directing projects or vetoing actions to monitoring day-to-day operations, all of which are difficult to weigh against one another individually, let alone when assessing them in different combinations. In fact, this court has never once found a corporation that was liable for its own judgments to be an arm of the state, even when the state had significant control over the entity. That includes cases in which the state was the sole shareholder, possessed appointment and removal powers over the entity's officers, and managed the entity's affairs. It also includes a case in which the state possessed appointment and removal powers over the entity's officers, veto power over its actions, and determined the projects it undertook. Footnote 5. This discussion is not intended to exhaust all considerations that may be relevant to the arm of the state analysis, and instead focuses on the considerations most pertinent to these cases. Additional considerations may apply, for example, in cases involving bi-state entities or unincorporated entities. Carrying on. Section C. Even if an entity is not an arm of the state, the court has long recognized that a state's sovereign immunity may still require dismissal of the action if the state is the real party in interest in that particular case. Although the arm of the state and the real party in interest doctrines are related, they can provide separate bases for dismissal. When a state is not named as a defendant in a lawsuit, it may still be the real party in interest. For instance, a damages claim against a state or federal officer in their official capacity is barred by sovereign immunity because the real party in interest is the government entity, not the named official. Similarly, a particular remedy may be barred by sovereign immunity if it runs directly against the state. In these instances, the case or remedy requires dismissal because the state is the real party in interest, not because the named defendant is an arm of the state. This court's decision in Hopkins versus Clemson helps illustrate the difference between these two related paths of analysis. In Hopkins, a plaintiff sued a state college for building an embankment on the side of a river, which redirected the river's flow and ruined his downstream property. He sought both damages and an order to remove the embankment. The court held that the damages claim could proceed because the college was not an arm of the state, explaining that the college was instead a corporation that might sue and be sued, plead and be impleaded in its corporate name. Nevertheless, the court explained that because the state owned the title to the land on which the embankment sat, the state might be a necessary party. If so, any order to remove the embankment would run directly against the state and would require the state's consent to be sued. The court therefore remanded for the lower court to determine whether the state was a necessary party and to strike that part of the suit if it was. In other words, the injunctive remedy would have required dismissal if the state were the real party in interest, but not because the college was an arm of the state. Footnote 6. NJ Transit has never argued that New Jersey is the real party in interest in either of these two cases. These cases therefore do not implicate whether dismissal is required on this ground. Carrying on. Part 3, Section A. Under the principles articulated above, NJ Transit is not an arm of New Jersey. To start, New Jersey structured NJ Transit as a legally separate entity. NJ Transit was created as a body corporate and politic with corporate succession. Consistent with that label, NJ Transit possesses typical corporate powers such as the power to sue and be sued, enter into contracts, and purchase or otherwise acquire real or personal property, among others. It also has the power to make and alter bylaws, set and collect fares, raise funds from gifts, grants, or loans, establish its own operating divisions, adopt and maintain its own employee benefit programs, and even own and control any corporate entity that it acquired or formed to carry out its statutory objectives. NJ Transit's corporate status serves as strong evidence that it is not an arm of the state. True, NJ Transit's organic statute also labels it an instrumentality of the state. The term instrumentality, however, lacks the historical weight the corporate form carries and says little about whether an entity is an arm of the state. Moreover, other aspects of New Jersey law undercut any inference that the term instrumentality favors NJ Transit's position. The New Jersey Tort Claims Act, for instance, excludes entities with sue and be sued authority, like NJ Transit, from its definition of the state. The New Jersey Contractual Liability Act also specifies that entities with sue and be sued authority are not part of the state. All told, NJ Transit is therefore structured as a legally separate entity under state law. Second, the state is not formally liable for any of NJ Transit's debts or liabilities. New Jersey law provides that no debt or liability of the corporation shall be deemed or construed to create or constitute a debt, liability, or a loan or pledge of the credit of the state. Before this court, NJ Transit concedes that New Jersey is not formally liable for NJ Transit's debts. Finally, the control that New Jersey exerts over NJ Transit does not change the overall conclusion here. Undoubtedly, the state exerts a substantial amount of control over NJ Transit. The governor has appointment and removal powers over the board. A state cabinet member, the Commissioner of Transportation, chairs the board. The governor may veto any of the board's actions, and the legislature may veto some eminent domain actions. On the other hand, New Jersey law states that NJ Transit shall be independent of any supervision or control by the Transportation Department or by any body or officer thereof, and requires that it exercise independent judgment. In addition, the governor's removal authority for 8 of the 13 board members is limited to for-cause removal. This level of control does not meaningfully affect NJ Transit's status, given the fact that it is a legally separate corporation and is responsible for its own judgments. Section B. NJ Transit's and its amici's counter-arguments are unavailing. To start, NJ Transit contends that formal corporate status, which ordinarily includes sue and be sued power, is not dispositive in the arm of the state analysis. True, as described above, the corporation label itself is not dispositive. NJ Transit, however, is a corporation that has all the hallmarks of separate legal personhood, such as the power to sue and be sued, make contracts, and hold property in its own name, which all indicate that it is not an arm of the state and does not share in its immunity from suit. This court has not previously found a similarly structured corporation to be an arm of the state. NJ Transit also contends that this court's precedents have placed little weight on the formal aspects of corporate separateness, such as sue and be sued clauses, citing State Highway Commission of Wyoming versus Utah Construction Co. for support. First, that case does not help its position. There, the court held that a suit against the State Highway Commission of Wyoming had to be dismissed for lack of diversity jurisdiction because the contract at issue was between a construction company and the state of Wyoming, acting through the Highway Commission, and thus the real party in interest was the state itself. Given that the suit, in effect, was against the state and must be so treated, it was unnecessary for the court to consider other formal aspects of legal separateness, like the Highway Commission's grant of power to sue or be sued. The important fact was not that the commission was, in the abstract, an arm of the state. It was rather that this particular suit was against the state as the real party in interest. Second, and more importantly, many of this court's cases throughout history have emphasized that the corporate form, which typically includes the power to sue and be sued, weighs strongly against arm of the state status. Footnote 7. NJ Transit also relies on several cases that did not squarely confront the arm of the state inquiry. Two cases addressed whether and to what extent a sue and be sued clause waives sovereign immunity. Neither case addressed the relevance of the clause with respect to the arm of the state inquiry, however, because the court assumed in both cases that the entities at issue were entitled to sovereign immunity to begin with. Another two cases held that a plaintiff state could sue another state for actions taken by a state-created corporate agency at the defendant state's direction. Those cases did not address whether the corporate entities were arms of the state, such that every suit against them should be considered a suit against the state itself, but rather held that the state was the proper defendant in those particular cases because the state directed the agency to conduct activities over which the plaintiff sued. Carrying on. Next, NJ Transit argues that New Jersey demonstrated its intent to create NJ Transit as an arm of the state by describing it as serving public and essential governmental functions and delegating to it substantial plenary public powers, such as the power to operate a police force, exercise eminent domain power, and promulgate regulations. The arm of the state analysis, however, focuses not on whether the entity serves public functions, but rather whether the state has chosen to serve those public functions through its own apparatus or through that of a legally separate entity. That is why the court has long recognized that cities and counties are not arms of the state, despite serving public functions and exercising police powers. That is also why a charitable organization may undertake rescue or other good work which, in its absence, we would expect the state to shoulder, but none would conclude that in times of flood or famine, the American Red Cross, to the extent it works for the public, acquires the state's immunity as a result. Moreover, assessing what qualifies as an essential governmental function can be unsound in principle and unworkable in practice. It has the tendency to produce inconsistent results and hamper states' abilities to experiment by forcing them to pay an added price when they meet the changing needs of their citizenry by taking up functions that an earlier day and a different society left in private hands. Here, for example, transportation services and infrastructure are not readily classified as typically state or unquestionably local, given that states and municipalities alike own and operate bridges, tunnels, ferries, marine terminals, airports, bus terminals, industrial parks, and also commuter railroads. What is more, as shown by the history of NJ Transit itself, these services and functions used to be fulfilled primarily by private railroad and bus companies. Instead of deciding whether the operation of commuter rail and buses is a governmental function, the arm of the state analysis concentrates on the fact that New Jersey chose to pursue those functions through the creation of a legally separate corporation. NJ Transit also contends that the court should consider not only formal liability, but also the practical reality of its financial relationship with the state. According to NJ Transit, This includes whether and to what degree the state funds the entity and whether the state is likely to voluntarily pay the entity's judgments. In support of this position, NJ Transit relies on Lake Country and Hess. Neither case bears the weight NJ Transit places on it. It is true, as Lake Country explained, that this court has allowed entities to invoke sovereign immunity in order to protect the state treasury from liability that would have essentially the same practical consequences as a judgment against the state itself. That statement, however, relied on cases concerning whether a state was the real party in interest in a particular lawsuit. As discussed above, that is a separate question from whether an entity is the arm of the state. On that question, Lake Country's arm of the state analysis discussed only whether the compact expressly provided that obligations of the entity shall not be binding on either state. Turning to Hess, that case framed the inquiry as asking whether the state was in fact obligated to bear the entity's judgments both legally and practically, and mentioned that the entity had generated its own revenue for years. In answering that inquiry, the court focused on whether the compact or the laws of either state required them to do so, and the court ultimately concluded that the state's lack of legal liability for Port Authority debts and formal responsibility for the payment of judgments cut against arm of the state status. Hess's concentration on formal liability rather than an overall evaluation of the entity's financial relationship with the state is confirmed by this court's other precedents as well. Footnote 8. Has also discussed two circuit cases involving transit facilities that placed heavy fiscal tolls on their founding states. In those cases, even though the entity's originating statutes did not make the states liable for their judgments, the states operated the respective entities under distinctive federal statutory obligations not present here. Carrying on. Hinging an entity's arm of the state status to the practical realities of state funding also risks arbitrary distinctions and inconsistent treatment of the same entity. These cases illustrate the problem. In the last 35 years, New Jersey's funding of NJ Transit's annual operating budget has oscillated anywhere from 15% to 46% of the budget. Although NJ Transit maintains that it has always been an arm of New Jersey, it offers no meaningful way to decide how much funding is enough to prove it is financially integrated with the state and financially dependent upon it. The more apt question instead is whether the state would be formally obligated to pay the entity's judgments. More generally, NJ Transit advocates for an arm of the state inquiry that places more weight on the state's control over and practical financial relationship with the entity. For support, NJ Transit points to a series of cases outside the sovereign immunity context. As those very cases warned, however, an entity can count as part of the state for some but not other purposes. Accordingly, the analysis in those cases has little bearing on the arm of the state analysis here. Finally, 23 states contend as amici curiae that the current use of the multi-factor balancing tests in the lower courts has created significant uncertainty. To address this problem, they urge this court to adopt a rule that a state's own characterization of an entity, such as New Jersey's labeling of NJ Transit as an instrumentality of the state, should be dispositive. One problem with the state's position is that it focuses on the label a state places on an entity rather than assessing whether the state structured the entity as legally separate. Another problem is that the state's position prioritizes one of New Jersey's characterizations, the term instrumentality, over another, body corporate. There's no good reason to believe that the state intended for NJ Transit to be part of the state itself by using the word instrumentality when it simultaneously used the word body corporate, a term traditionally understood to create a separate legal personality. The state's preferred test that any label a state chooses is dispositive, therefore does not promote predictability in the treatment of state-created entities because it still requires courts to decide which state law pronouncement is dispositive. Instead, what promotes consistency is adhering to a long line of cases in which this court has found state-created corporations that are formally liable for their own judgments not to be arms of the states that created them. Of course, all states maintain the power to structure themselves as they wish. To the extent New Jersey and other states create such corporate entities intending that they would remain part of the state and that the state would formally assume their liabilities, the states are always free to amend their laws. Part 4. NJ Transit is not an arm of New Jersey and thus is not entitled to share in New Jersey's interstate sovereign immunity. The judgment of the New York Court of Appeals is affirmed, the judgment of the Pennsylvania Supreme Court is reversed, and the cases are remanded for further proceedings not inconsistent with this opinion. It is so ordered. And that does it for the opinion in this case. As with most unanimous decisions of the Supreme Court, this seems pretty straightforward. I mean, I'm not like familiar with this area of law, so um, yeah, I couldn't necessarily have told you what the correct result should have been before reading the opinion of the court. But yeah, after reading the opinion, assuming there's no like blatant mischaracterizations of the court's precedents, yeah, I mean, seems to make sense. You structure an entity as a corporation that has all the typical powers of a corporation, including the power to sue and be sued, and, which is responsible for its own liabilities and paying its own judgments and everything. Like, yeah, that's not an arm of the state. That is not part of the state. That is its own legal entity according to, yeah, all of the history of corporate personhood and all that, whatever. Um, and yeah, NJ Transit's counterarguments as laid out by the court don't seem to make a whole lot of sense. Like, oh, well, no, you should just rely on what the state says. It's like, okay, well, that doesn't really help in this case because the state said two seemingly contradictory things, at least as NJ Transit tells it. It says, oh, well, the state said we're an instrumentality of the state. Okay, but the state also said you're a body corporate, so which one matters, right? And plus, it would turn the whole thing into like a magic words test, which the court doesn't like magic word tests. Like, oh, well, the state said we're an arm of the state, so we're an arm of the state, completely ignoring the way that the entity is actually structured. That doesn't make a whole lot of sense to me. Apparently, didn't make a whole lot of sense to the court. Yeah, and then saying, oh, we're an arm of the state because we're performing governmental functions. Again, doesn't seem to make a whole lot of sense. Just because you're performing like important, public and governmental functions doesn't make you an arm of the state. A whole lot of obviously separate legal entities perform such functions. And yeah, as the court points out, like the question isn't whether the state is trying to undertake these governmental functions, these public functions or whatever. The question is, how is it attempting to undertake them, by its own state apparatus or by creating a separate legal entity? So just saying, oh, we're performing these functions doesn't answer the question. Yeah, and then it relies on a whole bunch of cases that don't really seem to support its position, and most of them don't even seem to really address the whole arm of the state analysis at all. Most of them are either dealing with completely unrelated questions, and the court saying, well, this is part of the state for these purposes, which of course doesn't imply that an entity is part of the state for other purposes, or, it's dealing with the related but still distinct question of, is the state the actual party in interest to this suit? So, yeah, I mean, I don't know. I guess I'm kind of just reiterating what the court said, but NJ Transit's counterarguments didn't seem persuasive. The court's arguments did. So, makes sense to me. Just about the only other thing I have to say about this opinion is, it doesn't really have anything to do with the merits or the legal inquiry or whatever. It's just this opinion was way longer than it needed to be, I feel. The start of the opinion is just a whole bunch of like going through unnecessary background, unnecessary history. There's parts of the opinion that address things that, it later says are completely irrelevant. So it's like, well, why did you bring it up then? Like, who cares? Uh, and yeah, I don't know. I felt like this could have been trimmed down a lot. This didn't need to be 30 pages. To be honest, towards the start of reading this, I was asking myself, like, this PDF document is 30 pages. This doesn't feel like a 30-page issue, right? This is a unanimous decision. This seems pretty straightforward so far. Yeah, is this gonna be, is there gonna be a concurrence or something? And it's like, no, it's just 30 pages, and a lot of it just didn't need to be there. And, while I was reading the syllabus, this was kind of funny. The syllabus is not written by any of the justices. It's not strictly part of the opinion. I just kind of start with it because it's there. And if listeners, just want to hear the syllabus and then move on, just get the summary of the opinion and then move on, cool, it's there. But while I was reading the syllabus, I found myself thinking like, this is a Sotomayor opinion, isn't it? Like, it felt like reading a Sotomayor opinion, and I don't know how to describe what I mean by that. It's just I find myself, for whatever reason, struggling through and not enjoying my readings of Sotomayor's opinions, um, or at least a lot of them. And reading the syllabus, I'm like, this I'm struggling in the way that I normally struggle while reading Sotomayor's opinions, and then I get to the actual opinion. I hadn't looked at the little, like, blurb that says who wrote the opinion and whatever, and I get to that little blurb, and it's Sotomayor wrote the opinion for unanimous court. I'm like, "I fucking knew it." And, uh, yeah, then I get to the actual opinion itself, and it's like, "Yep, this is not fun to read." So, I don't know. Maybe it's just my biases, but I mean, I say that, but then I'm like, but I like reading Kagan's opinions. Like, she writes so much better, and, she's sort of ideologically aligned with Sotomayor in most respects, so I don't think it's my biases. I think Sotomayor just writes worse than most of the other justices. But anyway, I think that's just about all I have to say about this opinion in this case. So, if I may ask you, my friends on the other side of the screen, please like, share, comment, follow the podcast wherever you follow podcasts, and if you would like to support it, you can do so on Patreon. The main content of the show will, of course, always remain free, but Patreon members get access to bonus or exclusive content, and they can request specific content, including other than reading Supreme Court opinions. With that, tune in for the next episode where we'll continue on through the Supreme Court's 2025 term. Until then.